language is contextual. You want to put, you know, the whole thing, I'm not talking about a 278-page complex construction contract. The relevant parts in context should be in an appendix so the court can see how they all fit together. Okay. Raises an interesting thing in terms of how you brief, and there's always a question about whether you should block indent stuff. The conventional thinking is that you cause the reader to pay attention when you indent and single-space something. And I have seen studies that actually show that the opposite is the truth. What happens when the eye hits single-space indented material is it skips it. They've had studies of what people's eyes do. It's too much work. And so what I always did when I was a lawyer is I would break that stuff up. I would force the judge to read my stuff, right? If it's important, I don't want to have any clues. Here's the indented single-space contract or statutory provision that I want you to read. If they won't, just work it in so that you don't see it coming. Or the other thing is to, and I've seen this, Tim Terrell, the professor at Emory, who does some wonderful stuff on legal research or legal writing techniques, talks about signaling. If you're going to quote, don't take any chances that somebody's not going to read it. Tell them what it says, and then quote it. Right? It's a little redundant, but you know, redundancy is not the worst thing in the world. Okay? Questions about that? Don't use Latin. I know it's law school. If you want to impress your friends. In my class, we have fun with some Latin rules, and it's great to have them in your pocket, but it doesn't really do anything. The only Latin I ever knew was quid centis de undequin quagentis. How about them 49ers? There's a wonderful book. It's by Henry Beard. He used to write for Saturday Night Live and just happens to be a Latin scholar. It's called Extreme Latin, How to Release Your Inner Gladiator. And he has a wonderful bunch of Latin quotes. Nolite me culpare suffragate sum erae porcali. Are you impressed? Anybody go to Catholic school? Don't blame me, I voted for Miss Piggy. Okay? What? The third thing that we want to talk about, remember why you're there, remember who your audience is, finally remember who you are. You are an officer of the court. You are there to help the judge. You are a person on whom the courts rely. Lose your credibility. You don't just lose your case, you could lose your career. Okay? You need to remember who you are. You must be scrupulously honest about your characterization of the record. If there are facts that you would not like somebody to know, don't pretend they don't exist. You have to deal with them, and for heaven's sakes, don't mischaracterize them. The same applies to the law. The cases are what the cases are. You have an obligation as an officer of the court to report any relevant cases to the court, whether they favor your argument or not. And once again, why wouldn't you want to do that? It's not just a question of ethics and avoiding getting in trouble. Remember again, the first thing we talked about, why are you there? If there's a case that's out there that it goes against the argument that you want to make, think it through for a second. Do you really think I'm not going to find it? Do you really? Why do you think we have law clerks and staff attorneys and computerized legal research systems? What are the odds? You found it, right? Do you really think I'm going to miss it? So what are the odds it's going to do you any good to try to hide the law? It isn't going to work. It's only going to make you look worse, which will not serve your client, will not address why you're there, which is to get the court to do something on behalf of your client to agree with you, and isn't going to help you in the long run. Yeah?
Landau, with respect to like different treatment of the same issue, like non-binding precedent. So, for example, at the state level, another state's precedent on the same issue, which may be adverse to your position.
Yeah.
I mean, to what degree, say it's like an 1821 case from Wisconsin, for example, to what degree, if it's adverse in that sense, does it really need to come into the brief? I mean, is it just how it's generally treated by other courts? I mean, if it's something that's cited as a rule, then obviously it comes in.
Yeah.
But
if you are in Oregon and there is Oregon precedent that controls, if you're in the Court of Appeals, you're arguing in the Court of Appeals, and there are Court of Appeals cases or Supreme Court cases, and they're on point or in the neighborhood, you ought to be talking about it. If you're in Oregon talking about an Oregon issue of statutory construction or Oregon common law, and you know that there's an 1821 case from Massachusetts, fine, I don't care. Raise it to us if you think it would be of persuasive value. Don't raise it. We're not talking about that. Okay. There's an interesting flip side of that, and what we see often, particularly in common law cases, is lawyers will nose count other jurisdictions. It also arises when we have insurance policy cases, because most insurance policies are just foreign policies that are nationally used, and so there are lots of cases out there from other jurisdictions. And so what we'll say is, lawyers saying the clear majority view is, well, yeah, there have actually been 11 states that have addressed this issue, and 5 of them go one way, and 4 of them another, and 2 of them said beats the hell out of me. That kind of arguing isn't really very persuasive. We're not bound by any case law from any other jurisdiction. It doesn't have any precedential value to us. If it has value, and by the way, it doesn't matter to any court what the majority rule is out there on an issue that this court hasn't addressed yet. I mean, there could be 48 states that do it one way, and if Oregon hasn't decided it yet, it'll be interesting, just because what are the odds, right? I mean, 48 states, they probably know what they're doing, but not necessarily. We're in the minority on a number of different issues. What persuades is the logic, the coherence of a position reflected in another state's case. Not because it's from California or New York, or that it's not from California or New York, depending on your point of view. It is the persuasive value of the arguments that the court adopts in one state or another. And in fact, I've said that in opinion, saying, please stop arguing. The lawyers on one side say, ours is, the position that we're arguing is the majority view, and the other one says, no, it's not, ours is the majority view. And they said, no, you're not counting right. I don't care. What I care about is the strength of the argument, the persuasiveness of the reasoning that's reflected in any of those other state cases. Other questions about that? Yeah?
How much do you pay attention to the public reaction to your opinions? Like, for example, the Landau Online's reviews of your opinions, or when the press treats it. Do you follow that at all?
Yeah. I'm human. I'm actually kind of morbidly curious about how what we do gets perceived. And it's interesting to me what I think is going on in a case, and how sometimes that doesn't seem to bear any relationship with what the press thinks is going on in a case, or some website thinks is going on in a case. And I just think that's kind of curious. In terms of the decisions themselves, it makes absolutely no difference. In 17 years, I've never heard anybody talk about public reaction to a case in the process of deciding it. It's just never, ever happened. And we've decided some fun and interesting cases along the way. Some fairly controversial ones, and I'm real proud to say that it's never come up. Nobody cares about that. That's not why we're there. We took an oath of office to fairly and impartially decide these cases, and we take that very seriously. But that doesn't mean I don't read the newspapers. Yeah?
Sort of piggyback on that, I mean, I'm sure you have